All right, honey. Drum roll. Crime Cognition again. It's been a while.
Yeah.
Took a break for a little while.
Yeah, we were busy. I had some big cases that I needed to wrap up. Some reports I had to write forensically. I was super busy. You were very, very busy yourself.
Yeah, I've been had some jury trials. We had one in the office, which took me back to Baton Rouge, and I had a little time over there. But and just gotten very busy with clients and being hired some big cases, some big federal cases, and having to put a lot of effort and time into that. And we don't want to just show up here and say whatever, but we kind of wanted. But we also kind of decided not to prepare a lot. What do you think about that?
Yeah, we were getting a little analysis paralysis. We were having maybe too much anxiety or stress about kind of the putting together some particular package, because I think we're both perfectionistic in that way.
About getting it right.
Yeah, about getting it right, and maybe adding in, video, true crime video clips and things like that. And I think we just decided that let's talk about cases in a way that's really authentic, that is also unique to our respective fields.
Great. So here we are,
Yeah.
talking about Bryan Kohberger.
Yeah.
Which is something we've discussed a lot we've discussed a lot at the house, but haven't discussed on Crime and Cognition. So Crime and Cognition episode 4, I think?
We're on 5.
5.
Episode 5, and this is the Bryan Kohberger
Bryan Kohberger.
case.
Which is super interesting. So let's start with a bit of what is it?
Yeah, well, the incident happened in November of 2022. And so there's 4 victims involved. And I think it's important we first start off with honoring the victims. And we're not trying to glorify Kohberger. We're not trying to make this sexy in the way I think a lot of true crime junkies are fascinated with these things, and which is fine, but we're not trying to glamorize this. We're simply bringing our respective fields of expertise and our training, education, and experience therein. We're bringing all that to these particular subject matters. And this one is a national case that's going on right now. He is in active adjudication. The trial is almost underway.
And it's important for us. It's important for us to both acknowledge that there's very rarely a victimless crime. That there are real victims here, and whether or not we believe Kohberger committed this crime, or whether or not he did not, whether he's eventually found guilty or not guilty, nonetheless, none of those things will change the fact that there were these 4 deceased young people who obviously didn't deserve their fate on that particular evening. And we want to acknowledge that right off the bat, and acknowledge these young people lost their lives. Someone took them, and then from there sort of talk about what we think about the case. To be clear, also, I did a little piece on CNN about this case and about genetic genealogy, and we'll get to that in a minute. We'll talk a little bit more about that, about genetic genealogy and what role that plays. But I think we wanted to talk about some other stuff first. And
Before we do, the victims, I do think we can honor them, state their names.
Okay, sure.
Ethan Chapin, he was age 20. Xana, Xana, Xana Kernodle, age 20. Madison Mogan, age 21. And Kaylee Goncalves, age 21. These were 4 students from the university, and they lived in an off-university house near campus. And some of the folks in the home were not even residents of the home. They were friends.
And there were a number of people in the home that were left alive.
That's right.
At least 2, right?
At least 2 roommates that were left alive, yeah. And so these individuals were stabbed in the early morning hours while they were asleep, while they were in their rooms.
God, yeah, it's crazy. Just nuts. And really early morning hours. I think one of them was on TikTok or something, or posting on some social media at like 4 o'clock in the morning.
And one had just gotten in some kind of an Uber a food delivery,
Right.
delivery
Yeah.
minutes, like 10 or 20 minutes
Right before.
right before she was killed.
It's an interesting thought. Do you think that the killer, whomever did this, may have thought that the Uber driver would be blamed by going in right after the Uber driver? Is there that much thought involved, do you think?
We're going to talk about that. We're going to talk about that. I
Right.
believe this was an organized, as opposed to disorganized crime. And when we talk about behavior profiling, that's kind of as good as it
I was
gets.
going to say, tell me more about this organized, disorganized
Yeah.
distinction, because I don't believe that's a thing that's sort of part of the normal, vernacular.
Well, there's the FBI loves to talk about criminal profiling. There's shows devoted to this.
Right.
And that is kind of the sexy, glamorous side of the field that is largely unsubstantiated by literature. We know that you can't look at blood spatter on a wall and make some inference about the alleged perpetrator hated his mother and therefore stabbed the victim in such a way that the blood landed like this. I mean, it just doesn't work like that. And I mean, I'm giving kind of a preposterous example here,
Right.
but
So
really,
many layers of disconnect. But that's kind of the crux of it, right? Is that there are so many layers of disconnect between the sort of evidence they use to show or to say from these matters or facts, you can then lead way down the road to this thing that's quite circuitous to get there, right?
Right.
Does that make sense?
it does. And I think where we have to be really intellectually honest is what the data supports in the peer-reviewed literature on this, on behavior or criminal profiling. And it is that the best chance we have at kind of recognizing offenders from the state of a crime scene, so those crime scene variables, is whether or not the offender did this in a very organized and premeditated sort of a way, or whether this was really a spontaneous, unplanned, impulsive act.
Disorganized.
Yeah, right, that's it, the disorganized. And that's really the only distinction that is actually supported by peer-reviewed, scientific journal articles, scientific studies on this. The rest of it is still being developed. And some of it's like way out there, like the crazy blood spatter analysis I gave. I call those woo-woo psychology concepts.
Right, making a psychological assertion from a set of completely unrelated evidentiary circumstances. He used this kind of buck knife, and the buck knife was purchased over here, and then it was because his dad gave him one when he was 7, and his mom, had abused him right before that, and so, right, that kind of nonsensical, circuitous sort of putting some psychological value on
Or
otherwise-
a framework, like a
on-
framework when you don't know it. You don't have that framework. We just don't until we interview them and then find out, post hoc.
I see.
So
putting that sort of stuff on there, putting psychological value to certain things is
right.
It's iffy in the science.
Yeah, and so to kind of bring this back to your original question, which was the Uber driver, or I'm assuming Uber Eats, but we'll just call it delivery driver. I'm certainly not trying to promote that company. The delivery driver shows up, and the assailant is 10 minutes after the fact. He comes in, 10, 15, 20 minutes after this.
Yeah.
And so your question is great. Like, was this like deliberate?
Could he have seen that happening and then waited and then been like, oh, they might blame him, so I'll go in now?
I think that would be speculative on my part. We simply don't know what the attacker was thinking. But what we do know is there's elements of the crime that indicate this was organized. This was premeditated. There's a lot of things, and I don't want to get too far ahead, but
Right.
but that's a really good question.
There are some facts that you can point to that would show or will show this idea that it was organized in some way, using the distinction you just made.
That's right.
I see. Okay. So let's talk about who Bryan Kohberger is. He is 28 years old. PhD student, or was at the time, PhD student in criminology at Washington State University, which is about 8 miles from Moscow, Idaho.
Yep.
Which was interesting because one of the things that was funny about this is that when we first started talking about this, we couldn't figure out where he was because I'm like, he was at Washington State and he drove to Idaho. Like, man, he drove across the country. I'm bad at geography, obviously. It's only 8 miles away. Super close.
Right.
So there's the one big university in Moscow, Idaho, that is really close to Washington State University as well.
So, admittedly, I have consumed a lot of information about this case. Okay. We have talked about it a lot. We've read news articles. I have been listening to the podcast that's about it. That's on streaming on Apple. There's a whole series devoted to this case, and the podcast came out, I believe, in early 2024, sometime last year. And there's an episode where the podcasters are interviewing a student who was Kohberger was the TA, the teaching assistant. And oftentimes in PhD programs, the grad student does that. They either are filling in for a professor, or they're teaching a class, or they're sort of a teacher's aide in that capacity with undergrads. And so this was an undergrad, and he was the TA for this undergrad, and it was some criminology course. And the podcasters ask her a lot of questions, and there's really not a lot of substantive information she gives. My takeaway was that he was very matter-of-fact and kind of business-oriented and quite professional in his interactions with the students.
But specifically, and I think I remember you telling me about this when you heard it, specifically not a disorganized personality, not someone who's having psychosis or actively psychotic or actively out of control or whatever. I'm gonna let you speak to that, but I remember thinking, well, this is presenting as a pretty regular sort of organized thinker.
That's right, and I think what you're getting at is his defense gearing up for the sanity defense, right? Or some mitigating variables to try and mitigate either his, whether or not he was guilty, or probably at the sentencing phase of his adjudication process.
Right, mitigation and sentencing to say he was X, Y, or Z, and that relieves him from maybe a death sentence or a life sentence or whatever.
Yeah, that's right. And so what this student essentially discusses is that he was very organized, he was very meticulous, he showed up to class all the time, he held office hours for students, and he showed up, and he was helpful. He was just like any other TA, any other teaching assistant that you would see at any PhD program. It sounds like it was pretty run-of-the-mill stuff. Nothing stood out to me. And that's important because when somebody is psychotic, by definition, that means they have a detachment from reality. They're experiencing altered sensory states or delusions that are, removing them from present reality.
And so, someone who's fluidly psychotic in the moment is going to show that. People are going to have that experience of them, is what you're saying.
Yes, I love that phrase, florid psychosis. It's a great description of the blooming of somebody's detachment from what's really going on. And you see that pretty overtly. It's difficult for a lot of people to hide it unless they've been living with psychosis for a very long time. They kind of get used to the hallucinations, whether they're auditory or visual, or they may not bring up their delusions in conversations. They just sort of avoid discussions about those things. So it's possible for someone to mask psychosis, but to the degree to which somebody's psychotic and they're using the sanity defense, we want to see that there's this really pronounced deterioration in their functioning.
Here's a really interesting insight into criminal defense world and coming up with a defense and what it feels like to have a client that you want to say, on the one hand, look at this person, he's normal acting, he's regular, no one would suspect he would commit such a heinous act of violence.
Right.
I mean, just a phenomenal act of violence, right? He's a regular guy, he's doing all these regular things. But then if he's convicted, then you can't come back on the backside and say, well, he's not regular, he's got these problems. And so it's a balancing act in criminal defense. Like, where do you go with this? Do you say he was regular, then ruin an opportunity for mitigation on the back end? Or do you say, look, he may have presented like this, but he was actually kind of losing it and not a member of reality, even though he was capable of appearing so, in order to help a mitigation case, but maybe set the stage for an easier conviction? And that really has to do with the measure of the total evidence, right? As a criminal defense attorney, you have to say, am I making a factual case here that I'm going to win at the fact stage in front of a jury? Or have I absolutely lost this case before it's even started at the fact stage, and am I just building a mitigation case on the backside?
Right. This is interesting. I'm teaching my undergrads. I'm teaching forensic psychology to undergraduates this semester at Loyola University in New Orleans. And just this week, the lecture is going to be about not guilty by reason of insanity cases. And what I hope to drill home to my students is that there is a difference between when someone was experiencing some sort of psychotic state at the time of the crime versus present day. And usually that's where a competency evaluation comes in, is are they competent to stand trial? Somebody can be insane at the time of the crime. We wouldn't use that as a diagnostic label, but legally that would be the legal terminology there. They can be insane at the time of the crime, but also competent to stand trial. Maybe they've had an adjustment to their medications, or maybe they're now taking medications.
Never before been medicated.
Or they weren't taking them at the time of the alleged crime, and so now they're stabilized. And so there's certainly a distinction there, but there's also these at the crime behavioral characteristics that could be used against the person, the defendant, that maybe they were engaging in certain behaviors where someone could say, oh, see, aha, you were the getaway driver, so you had to have know what you were doing at the time.
Right. Oh, that's interesting. In fact, I remember, didn't you show me just yesterday or the day before doing the lesson plan how there are all these sort of misinterpreted matters, right? And this is one of those cases where you can certainly misinterpret some matters and say,
right,
well, he was way more high functioning because this and this and this. Or you can say, you can go the opposite direction, right? No, he was really messed up even though he was doing this and this and this.
That's right.
He nonetheless had these issues and was like, having these psychotic moments, or these moments that would make him in some way less culpable, less responsible for the crime, right?
Yeah, so let's talk about where he is in the adjudication process.
Sure.
So he's arrested in December of 2022, and this is definitely in your purview. What do you think about the data, or the evidence, I should say, that was used to arrest him?
So this is interesting. This is the genealogy thing, right? So they were focusing on a couple of, probably more than one person, right? You would hope that a good law enforcement officer isn't going to get one suspect and then hone in, right? That's a lot of mistakes arise from an early suspect being developed, and then law enforcement detectives sort of honing in on that and ignoring evidence of others involved.
Yeah, an a priori hypothesis is where we want to avoid that in the psych field too.
Yeah, and so and that happens in the field. So
right.
So I'll give the law enforcement the benefit of the doubt here, and maybe they had multiple suspects at the time, right? But they had identified Kohberger as a possible suspect, but they couldn't do anything with that, right? There was some DNA at the scene that they tested, an unknown profile they developed at the scene.
And they found that DNA on a knife sheath, right? It was a button on
Correct.
A very specific knife sheath.
That's correct. So a knife sheath that there is some pretty strong scientific pathology kind of post-mortem pathology examination that can tell you what kind of knife caused a particular kind of slice or stab. Mm-hmm. From the depth and width and those kinds of things, right? It's a fairly straightforward, you can't say it was this knife made by this company, but you can say the knife had a X, this length blade and a this width blade, and it was sharp on one side but not the other, that kind of thing.
But he left the knife sheath behind.
Well, that's the point. So the knife's not there.
Right.
And then the forensic pathologist makes a determination about the nature of the weapon used, and then they take that information, and there's a knife sheath there, right? And they say, well, you know what? This weapon used, the forensic pathologist saying that this is the kind of weapon used, is the kind of knife that would fit this sheath. So then they test the knife sheath, right, all over it. I'm sure they swabbed many locations on the knife sheath, right? But one of the things you swab is the button where you close the top of it, right? You put a knife sheath in, the hilt at the top of the knife blade like this sits in the leather, and then you snap it on the top so it can't be removed without unsnapping it. They tested the snap. There's an unknown DNA profile of some quality there. Now, that's not public information. I don't have that. I looked for that, by the way.
Yeah.
Quite a bit. Right before I went on CNN, I looked for the nature of that unknown profile. Was it a full profile? Was it partial? Is it a mixture? I mean, it's very hard to believe that it wouldn't be a mixture of some kind.
Right.
But you know, what was the profile? I just don't know. I don't have the answer to that. I haven't seen that evidence. But they develop a profile, and they think that Kohberger may be a suspect. So they find him at his parents' home in Pennsylvania, right?
Because he's now driven across the country with his dad.
Monroe County, Pennsylvania, right. So
Right.
they find him at his parents' home. They're observing him. They watch him throw something away, or the dad throws something away.
Right.
They pull the DNA off of this object. It's, in fact, what they then assert is that this DNA is the DNA of the father of the assailant.
I thought that they found that first, and that's how they narrowed it down to Kohberger. Then they go to the house and find Kohberger's DNA at the house, or in the trash.
I don't think so.
Okay,
Yeah,
okay.
I think they found the father's DNA from a piece of trash.
Oh, okay, okay,
Right?
okay.
And they're able to say, I mean, it's pretty straightforward genetic analysis to say that this person's the son or daughter, the child of this person, right? This half of the DNA,
Right.
half of the profile matches exactly half of this person, right? And so that's kind of
Yeah.
where it was, right? It was half of the profile they found that was the father matched, quote unquote, was concordant with, is the better way to say it, at least some portion of or all of the alleles present in the unknown sample.
Now, part of the defense strategy so far has been to try to get this excluded because they're ruling, or the defense team's arguing rather that the genealogy websites.
So genetic genealogy was used here.
Right.
And so, because I haven't seen the evidence, it's very hard, it's conjecture to say how it was used. It's my understanding that the genetic genealogy was used to find the relation between the father and the unknown sample. So that connection between what they knew was Kohberger's father's.
Because he
trash.
submitted it to some sort of Ancestry or 23andMe, right? That's kind of this commercial genealogy website. That's what it does, is you submit your DNA and then...
You do, and then so what they do is they not only do you submit your DNA, you submit both your mitochondrial DNA. So they get mitochondrial DNA to track your maternal line, right? The maternal line up from mother to children, but mother to daughters then passed on from mother to daughter to the next generation. So it goes up the maternal line and down every branch of the maternal line. So as it goes up, it gets wider and wider.
So these DNA websites are collecting this type of data.
And this genealogy is the same thing with the male genealogy. The male patrilineal line that's used is through STR testing or regular DNA testing, right?
But doesn't this mean his father submitted
it's Y
his...
chromosome testing.
Okay.
It's Y chromosome testing. So what they do is they analyze just portions of the DNA that are on the Y chromosome, and they can tell that of course is passed from father to son. Right?
Sure.
And because mom doesn't have one. So father to son down the line, right? And that's how they do genetic genealogy. Mitochondrial DNA and YSTR DNA. Right?
But how is the dad in the website? How was he in this? He submitted his DNA.
Someone
through a kit.
submitted their DNA in his family.
Okay.
Someone in the patrilineal line.
Submitted their DNA. It
Someone
may not have
up-
been the father.
Might have been the uncle, might have been a first cousin, might have been a fourth cousin twice removed, but it's within the patrilineal line of this YSDR DNA.
Yeah, I think that's
And
where
that's
lay
the
people.
connection they made.
Yeah, I mean, lay people like me who are not genetic experts, we want to know, like, what's his dad doing in the database? Where's that coming
It
from?
may have been his dad. He may have decided he wanted to know where he was from in the world. Right?
Yeah, right.
Same thing, right? The normal kind of where he was from in the world. And so it may have been his dad. It may have been an uncle. It may have been a cousin. But it's a male line, patrilineal line person in the family.
Yeah.
Again, some of this is conjecture because I don't have the actual evidence in front of me. So it's very difficult to sort of key in on exactly where it came from.
So we're assuming that this is from a genealogy kind of website. Is
It's
that?
my understanding from defense motions that it was in fact, they did in fact, no question, they took information from these public genealogy websites
Right.
and conducted a genealogy research and made the connection with that. But the specifics of that, I don't know.
And then this was ruled on. The judge said, no, I'm allowing this.
Yeah, because it's, if you put your information out there, you've made it public, and then so you don't have any more, you no longer have an expectation of privacy regarding that information.
Yeah.
And that's been pretty specifically held over and over again in these cases.
So we've got that's how he's arrested. And so now he's been indicted. He did not actually do anything during his plea.
He refused to say anything. The judge entered a plea of not guilty.
That's right. What do you think of that?
Yeah, that's a strange in the moment kind of thing. Who knows? People, maybe his lawyer told him not to say a word.
Well, have you seen that happen?
I have. Yeah,
Okay.
yeah.
How often does it happen in your experience?
1 in 100, 1 in 500.
Okay.
I mean, it's rare.
So it happens, but it's rare.
It's very rare that you have a defendant that won't say anything. And a judge will generally say something like, "Look, I'm gonna make note in the record that you have a refusal to talk, and I'm gonna enter a plea of not guilty for you. You wouldn't be allowed to plead guilty today anyway.
Right.
Do you object to me entering a plea of not guilty for you? I'll take your silence as acquiescence and enter a plea of not guilty for you." Right? That's kind of how that goes, right? I mean, it's you generally at arraignment, you're not allowed to plead guilty anyway, even if you wanted to. So it's a plea of not guilty or silence, and judges just do it for like checking the box, like he's pled. Let's move forward,
Yeah.
which is in the defendant's best interest, frankly, because if he hasn't entered a plea, it's kind of difficult for the case to move forward, right? It kind of puts a pause on it, and that's not in any defendant's best interest.
Also in his best interest is that there was a change of venue from the Latah County, L-A-T-A-H, Latah County, to Boise.
Yes.
And what do you think of that from a trial perspective?
The rules regarding moving trials are different from state to state. So I don't know the law in Idaho. I'm a licensed Louisiana attorney in the federal system, but in the state courts there's different rules, right? Mm-hmm. I know in Louisiana it's very difficult to move it after the Jarrett Ambeau serial killer case in Baton Rouge. They tried to move it, and the Supreme Court basically just gutted all the rules relative to change of venue. Louisiana, you don't really have a right to change venue anymore unless the district attorney agrees.
And the Derek Todd Lee was a famous serial killer.
Famous serial killer in Louisiana,
Yep.
and he was driving around in a white truck, and they did all this stuff, all these stops with all these white trucks, and he was terrorizing Baton Rouge. 4 or 5 women were killed by him, maybe up to 7 or 8, and the attorneys moved to change venue. They were like, "Look, this has been terrorizing the people of Baton Rouge for a few years now," and the Supreme Court of the state just basically gutted the change of venue law. So in Louisiana it's difficult. In Idaho, apparently it's a little easier, right? And I think maybe the district attorney may have agreed and said, this is such a heinous crime in this small community. It's not possible to get a fair jury here. Let's move it somewhere else. So, and it was moved to Boise, is my understanding.
Yep, that's right. And the trial is set to begin on July 30th of this year, 2025.
Right. Which is a couple of years. When was he arrested? I saw that earlier.
December
30th, 2022.
That's right.
So it's been more than 2.5 years.
Actually, I stand corrected. Jury selection is starting on July 30th, and the trial is set to commence in August.
10 days later.
Yeah, 10 days later. That's a lot of time for jury selection.
Yeah.
Yeah. Yeah. Do you think they're going to need it
If it's a death penalty case, sometimes jury selection can take 2 or 3 weeks.
And this is a death penalty
They're
case.
seeking the death penalty.
The prosecution has stated they are seeking the death penalty. And that's kind of where the Atkins defense is going to come in here.
It's interesting. Let me say one thing
yeah.
about the death penalty. I think it's really interesting. I've left the camera on myself a couple of times. It's not good. The one thing I'd say about the death penalty thing, the reason it takes 2 or 3 weeks, you can pick a jury for a rape trial or a murder trial or just anything, a armed robbery trial in 2 or 3 days generally. I mean, if you go 8 hours a day, you can get that in 2 days, right? Even a really highly contentious rape trial, let's say, for instance, where you're going to exclude a lot of jurors are going to say, I cannot sit in judgment, or a child,
Yeah.
or somewhere a child's a victim, when people are going to say, I
Yeah.
cannot do this, I can't sit and see this, right?
Yeah.
You still get a jury in 2 or 3 days. The reason death penalty cases take so long is because you exclude anyone that cannot say yes to death, knowing that if they say yes to guilt, that death is the outcome. You get a lot of people that, a larger percentage that say they can't deal with that. And there's this thing called the Colorado method that criminal defense attorneys know real well. It's how to lock people down on that idea. You have a feeling that you wouldn't vote guilty if you knew that death was the outcome. If there was and you've not adopted that today, this is a feeling that you've had for a very long time. And if I brought someone in here in your life that was a mentor, someone that was very, very powerful in your life, your grandfather, your pastor, and they said to you, you abandoned those feelings. Don't you think that way? Would that work? No. Well, if the judge told you to abandon those feelings and not think that way and follow the law, would you do it? If that answer is yes at that point, that person's excluded and the judge can't save them. And so this is called the Colorado method. It's how you lock people down on and I do it in all jury trials. I do it in jury selection all the time. If I feel like somebody's dangerous, it's not going to give my client a fair shake, and I can lock them down on that, I will then use that method I just went through to make sure that I tell the judge, it doesn't matter what you say to them, judge. They're going to decide this way every time.
Yeah.
And I will tell you this, to a person, I've tried 60 plus felony jury trials, every single judge, conservative, not conservative, ex-district attorney, ex-defense, it doesn't matter. I'd say every judge I've ever been in front of wants to get it right. They don't want to do it again.
Yeah.
They don't want to clog their courtroom up with a second trial on the same issue. So if there's a problem, if there's someone that's really presenting a problem, they just exclude them. They're off the jury. I mean, it's almost, and you want it to be that way. You don't want it to be hard. You don't want to have to jump through hoops. You want a jury that's fair. And so that's why these jury selections take so long.
And they start with a large pool, a couple hundred, sometimes more people that they're whittling down through this voir dire process.
Correct.
Yeah.
Yeah.
Okay.
So you were just getting ready to talk about the Atkins defense.
Yes.
Talk about that, because that's in your wheelhouse.
Well, the Atkins case is a famous case from 2002, which was essentially the defendant was his IQ was tested. It was found to be a 57.
That's unbelievably low.
That's right.
How many standard deviations from the mean is that? Is that 4 or 5 standard deviations?
No, well, 2 would be a 70, so it's 15 points is one standard deviation.
Right.
So we're looking
more
at
than-
almost, yeah, yep,
God, yeah, that's crazy.
yep.
That's crazy.
And so that is in the intellectual disability range. Now, we don't just diagnose intellectual disability solely based off of IQ score. There also has to be 2 other criteria present. They have to have had, or have to presently have, adaptive functioning deficits. And these are your life skills. Adaptive functions are your ability to communicate, your ability to be safe, your ability to move around and be mobile if that's a possibility, if someone
these
doesn't
are
have
basic
mobility
life
issues.
functions.
These are basic life skills. The ability to socialize and communicate needs effectively.
Does someone like go to the grocery store and buy groceries? That kind
Not
of thing?
even that. It
That's
would be,
even more high
can you
functioning.
make a bowl of rice?
Oh, wow.
Or something even more simple. Can you boil water and boil eggs?
Without hurting yourself or doing something, yeah.
That's right. And then so it's really a retrospective look as well, because the third prong is, both of these areas have to be, 2 standard deviations below the mean, which is below a 70, standard score of 70. And they had to have occurred during the developmental period. Previously, the DSM stated before the age of 18, but we know that people are still developing into their early 20s. And so the language now is these deficits had to have occurred before the developmental period. And this is important because this is what differentiates something from, an intellectual disability from a traumatic brain injury, or an ID, intellectual disability ID, from somebody who's got, maybe neurological issues as a result of substance use issues. These are in utero, typically, in utero issues that are developing in the fetus, and the person is born. That's why we call it a neurodevelopmental disorder. They're born with these brain differences. And so that's really the 3 prongs. And that is what the Supreme Court established, is that it is a violation of the 8th Amendment, cruel and unusual punishment, to use the death penalty against someone who has an intellectual disability. And so that's the Atkins case in a nutshell. And I think that's where Kohberger's defense is going to probably go to, but...
It's incredibly difficult for a PhD student.
Yes.
Right? Who's, as you said earlier, organized, who, at the very least showed a very high level social skills, very high level teaching and giving information, being there for others.
That's right.
Organizing as a TA. I mean, these are all very high level skills.
You have standardized test scores. You have that he took the SAT or ACT upon graduation from high school.
Yeah.
He might have had IQ tests somewhere along the way in school if he was in any giftedness programs or just ever had a psychodiagnostic.
The GMAT? Is that the graduate exam?
The GRE.
GRE.
He would have taken very likely would have taken the GRE after he completed his undergraduate degree.
To get into graduate school.
Right.
Yeah.
So the Atkins defense for him is going to be an uphill battle.
Yeah, sure. That makes sense.
And then you turn to where I think this is probably going to go, the sanity defense.
So was he sane at the time?
That's right. Was he sane at the time? His defense team has introduced a psychologist who is a neuropsychologist. So that's a specific subspecialty within the licensed psychologist field. And so this woman, this psychologist, I can't remember her name right now, she submitted a report, which has not been released, but some excerpts or sort of paraphrasing of her report has been used in defense motions.
Interesting.
It is what they've stated, the defense in these motions, is that Kohberger has been evaluated and has ASD, autism spectrum disorder-esque or like symptoms.
Asperger's no longer used.
Autism.
Autism.
Did I say Asperger's?
No, I did.
Oh, okay. Sorry.
Asperger's no longer used, right, in the field anymore, but someone who's on the spectrum can be highly social, highly developed, highly, able and capable, but also have some features of autism? I mean, I'm curious about that.
It's a great question. That is the nature of the disorder itself, is significant deficits in social skills. So they wouldn't be highly social. What you would see is there's variations in cognitive abilities. So you're going to have some people with ASD, autism spectrum disorder, who have any level of IQ functioning. So
a whole wide swath.
A whole wide swath of IQ.
IQ is
right.
not correlative with autism spectrum.
Now it is, yes. Most folks with ASD are going to have lower IQs. But that does not mean that there's many folks out there with ASD who have normal to above average to maybe even savant-like IQs that are very high.
And we see that. One of the shows we like to watch is Love on the Spectrum. You love it.
I love that show.
And it's clear that there's some a wide range of functioning ability.
That's right.
In the people that are on the show, right? Just this little snapshot.
Yes.
You can see a very wide range.
Intelligence is not part of the ASD diagnosis. Okay. What is social skills deficits. That is one of the 3 major prongs that we see in this diagnosis. And so I don't know what tests this psychologist used. If she used what the gold standard test for autism is called the ADOS, the Autism Diagnostic Observation System. It's currently in its second iteration, and it is a very in-depth, complex, hours-long test. I was actually trained in it. I administered it for a number of years during my graduate studies, and then when I worked in some mental health clinics around New Orleans. It's the gold standard test. I'd be curious to see if she administered it. That's going to be, in my mind, what's really important to introducing any evidence that he has ASD-like symptoms is, okay, prove it. Was he given the gold standard test? And we don't have a report, so we don't know.
We don't know. Right. It's interesting to me, we're to roll back just a touch, we were talking about the insanity defense and somehow being incapable or understanding between right and wrong at the moment of the time he committed the crime, as opposed to maybe how he is now or how he was with people in class. In other words,
right.
Here's some pretty normal behavior, but in the middle here we've got this craziness or this inability to understand right from wrong or appreciate it. It's funny, we've done work together. We've had some cases together where prior to our being married, where you told me, I remember a particular case where you called me and just said, hey, your client was just angry.
That was a sanity case.
Yeah, it was a sanity case, right?
Yep,
And we did an evaluation, and I asked you to do an evaluation so that we can maybe prove that this person was insane at the time of the act, and you were like, look, I administered all the tests, the regular tests, everything we were supposed to do, the gold standard test, and it turns out your client was just really upset.
The data rendered from the psych eval did not match your psycholegal theory. And that happens a lot.
Yeah, and you told me, you were straightforward. You were like, this just doesn't match what what your idea was, right?
That happens a lot. I get grilled in court because attorneys want to pin you as a hired gun, or pin me or other forensic psychologists as a hired gun. And boy, I've run into some lately, some hired guns. I have run into some. Oh my word!
That's time for another podcast.
That is another. We have got to film an episode about that. But and I bring that up. That look, really about 25 to 30% of the time does a case actually that I'm involved with, from start to finish, go from initial consultation, evaluation, all the way to testimony. It just does not happen that often. Sometimes the data just does not align with what the attorney's psycholegal theory is.
I'm curious about this particular case, and maybe I'm jumping forward here, but I'm super curious because there's some information now out there that he may have been obsessed with one of these young ladies, that he may have been stalking or following her,
right?
That he may have interacted with her in a social setting, and that he may have gone over to the home to confront her or talk to her or do something other than kill her and everyone, the 3 other people in the room,
right?
In the house, And I guess my question to you is, my sort of layperson's brain says, well, is like gross obsession, does that count as insanity? Does, if you're like, if you grew up and you were put down by all these women and you'd never really had a girlfriend, or you had one but it wasn't great and you didn't really know, and then you were obsessed with this woman, you went over there to tell her how profess your love, and she flipped out on you and told you to go away because you're a crazy person.
Right.
But that sent him into a rage. Is that is that crazy? Is that enough for a sanity defense? What?
Well,
because I think laypersons want to say, well, look at this history and look at this set of circumstances and look what happened to him here. And he was beat as a child and it was physical abuse, or he was sexually assaulted by this this relative as a child, and so that's what made him this way. And then he went and did this. But that's not enough, right? Am I right in saying that?
It's interesting. There's a famous case, the Hinckley case. This was the Reagan assassination attempt.
Okay, yeah.
And the guy was obsessed with Jodie Foster. He had these really grandiose delusions that she was in love with him and they were going to live some fantasy life. Do you remember this case?
I do, of course, yes.
And he was found to be insane at the time of the crime.
I remember where I was when Ronald Reagan was shot.
Okay.
Because I was alive then.
Well, I don't know that I was, sweetheart. But I think it was in the 70s.
No.
Was it in the 80s?
Yeah, it was in the 80s. He was elected in 1980.
I thought it was 79. Okay.
In like 82 or something.
Okay. I was a few years off.
I was in grade school. I remember they announced it over the school.
Okay, well, that's back in the olden days. Let's
Olden
bring it up.
days.
So, but that's a case that is sort of what you're hitting on. But Hinckley had these delusions that were arguably serving to draw him out of reality, and he did not have the the wherewithal to know what he was doing was right or wrong.
Yeah.
And so that's where legal statutes
So I
come
guess
into.
at that level,
Yeah.
some of those things may actually lend themselves to an insanity defense.
Well, this is exactly the intersection of psychology and the law, because sanity is not a psychological term. We are using mental health diagnoses. We are discussing symptoms, and if it meets a diagnostic threshold, the diagnosis that fits. And so with respect to the sanity defense, each state has its own nomenclature and statutes about this. And if they don't, I think they follow the ALI standard.
Oh, that's interesting. Okay. Yeah.
Yeah. And for our listeners and viewers that don't know, what's the ALI?
I have no idea. What is it?
It's
Is it the American Legal Institute?
yes.
Okay. Okay.
Yeah, it's the model penal code.
Oh, okay. Yeah. All right.
Yeah.
All right. Yeah. Yeah. It's the model penal. There is a model criminal code out there
Right.
that states have used or used in the 60s, 70s to develop their own criminal codes when we began to have more forward thinking about criminal codes and criminal law and
Yeah.
began to really develop some of these like underpinning cases of criminal law. And so but every state's criminal laws are different. And though they be
That's
modeled,
right.
they may be fashioned in the same vein as these cases.
Right.
They're all different.
So in Louisiana, I've done a ton of sanity cases. I can tell you verbatim what the sanity statute is. It's, did the defendant have a mental disease or defect that precluded them from knowing right or wrong at the time of the crime? I've got that one seared into my memory.
Here's what's interesting. You are a psychologist. I'm a criminal defense attorney with thousands of cases.
Yeah.
I mean, thousands of cases. I've conducted more than 60 felony jury trials, and I have not had the amount of sanity cases that you have. There's no question. I've only had a handful of sanity cases, and being hired for them, you've had many more of those than I have. There's no question. Because I've only had 3 or 4 state cases where this is not cases where I asked for a sanity commission. This is a case where the sanity commission came back and said, this person's not capable of moving forward. I've only had 3 of those in almost 20 years. And 3 in the state court and 1 in federal. Yeah,
the sanity defense is raised exceedingly rarely. It's really about 1% or less of the time.
And in Louisiana, to be clear, one of the reasons that we don't do it in Louisiana is because there's no diminished capacity defense in Louisiana. There is either competent to stand trial or not competent to stand trial. It's binary in Louisiana, and there's nothing in between. And in fact, all other matters related to competency are inadmissible at trial if the person's been found to be competent, except battered woman syndrome, which is... Go look at our other podcasts if you're curious about that.
Yeah. So... This sanity defense is where I think it's hard to really know where Kohberger's defense team is going, but the use of the language about him having ASD, I think, is maybe where they're going to argue that this is a violation of his 8th Amendment right? To not be subject to cruel and unusual punishment.
Which to me is a setup for a mitigation case, what I talked about earlier.
Yeah.
You may not be able to win at the fact stage. I haven't seen all the evidence. I've looked at a good bit of it. I've looked at some defense motions. I've looked at some prosecution responses and motions. There seems to be a tremendous amount of evidence connecting Bryan Kohberger, not just DNA. To be clear, there's a lot of other stuff that's out there that we've seen that I read the record. There's a lot of stuff out there. There's a lot of information out there that he may have been involved in this. And as a criminal defense attorney, looking at that and the difficulty therein, just taking the DNA on its face, what's been publicly reported, not seeing the actual report, they may be building a mitigation case to stop him from being put to death.
That's right. And Idaho, we just looked it up, does not have a sanity defense option.
Oh, really?
No.
Wow. So what do you do there? It's something that's just admissible.
They
at
have
trial?
what's called guilty but mentally ill, but it's just as punitive. The
Oh, it's the same
potential.
punishment.
It's the same punishment, if not more punitive.
Wow. And so I guess that does sort of open the door for the defense then, if that's the case, if you can't assert that pretrial for the purpose of finding out whether or not he's competent, then it all must be admissible at trial to combat intent.
Well, you're saying competent. Do you mean sane?
Yes.
Yeah.
Yeah. So if it's not admissible before, if there's no vehicle for putting that evidence forward before trial, then that must open the door for a lot of that information coming in at trial, because the defendant has a constitutional right to mount a defense.
Right.
Can't stop a defendant from defending himself, and if he's got some information related to whether or not he could form the requisite mental intent to commit the crimes, that must be a defense to the intent.
That's it, mens
interesting.
rea. Yeah.
That's a really interesting. It really opens the door, although that sounds like it sucks because you can't do that pre-trial. It actually might open the door to some much more robust defense at the trial itself, which now makes more sense why they're filing all these motions, why they're doing all this pretrial stuff, why they're talking about all
Right.
this pretrial, because it's all admissible at trial.
Right.
To show, to challenge whether or not he had the requisite mental intent, the mens rea. Wow,
Yeah.
That's really interesting.
I think that's where they're going. That's
Yeah,
my
that makes
analysis of why they had a forensic psychologist. I don't know if she is a forensic psychologist or if she's just a neuropsychologist that evaluate him. I would assume she's a forensic neuropsychologist, so she's well versed in the forensic world. I would assume that she's
Yeah.
not just a clinical
Just a
expert that's works in a clinical capacity, because we really want to see someone has that crossover and has worked in the psycholegal world.
And has the experience and knowledge and training to administer these tests and do the testing and make an objective analysis of someone as opposed to a subjective.
Well, the malingering testing is a huge part of this in the forensic world. If she does this evaluation and she does not include any testing of malingering or validity testing, malingering is feigning or exaggerating symptoms for some kind of secondary gain. And in Kohberger's case, he has a massive incentive to malinger,
Obviously, right.
to evade successful prosecution. So,
All right, so
yeah. Okay.
that is the sort of psychological
Yes.
look at what's happening.
Yeah, let's look at it from your lens a little bit. I think that we've kind of intermixed that
Yeah,
a little as we've gone, but
we'll focus next time on the criminal defense, genetic genealogy, what's happening with the evidence itself, what I can discern at least from the record about the evidence and about the genetic genealogy. I'll be a little clearer about how that was done in terms of how the genetic genealogy was done in this case, what the use was, how they made the connection, and frankly the evidence that we could discern from the public record. And so tune in next week, maybe something like that, a week. Let's do it fast though, because the trial's coming up, so we want to get it done.
yeah,
We're
we're going to get it done.
We'll put out something about we'll do a little more criminal defense focused analysis of this same case up next.
Thanks for joining us.
Yeah, thank you. Yeah, it's been great. I'm glad we're back doing this again, and look forward to doing it some more. Thank you.